In our last talk, we talked about why people have to go through probate. And this time, we wanted to talk about the actual steps of the probate process in Colorado. I do want to point out that probate is different in every state. And so what we're talking about today are the specific rules for the state of Colorado. So what happens when someone dies is that the first thing we have to figure out is, did they have either $70,000 or any real estate in their name? And if the answer to either of those questions is yes, that means that we have to go through the probate process. What happens first is if there is a will, the will gets lodged with the court, which means that we send the original to the court and they keep it. And then at the same time, we submit a petition to the court asking the court to appoint the personal representative of the estate. Now, how do we figure out who the personal representative is? Well, it's easy if it's said in the will, right? If the will says this is the personal representative of the estate, then that person is the person who asks the court to be appointed. If there is no will, then the statutes say who will be appointed as the personal representative. And there's generally an order of priority, which would be first the spouse. If there is no spouse, then the adult children of the deceased person. And if there are no adult children, then the beneficiary of the estate. Now, it can be a little bit difficult if there is no will because the adult children may not necessarily agree as to who is going to be in charge of the estate. And that's why we encourage people to do their planning, so that they can say who will be in charge of the estate instead of letting the statutes say who will be in charge. Assuming that people aren't going to fight out who's in charge and we have a clear personal representative, that person petitions the court to be appointed, and if all goes well, the judge is going to appoint that person. And then they're going to issue a document called letters. Letters is a court order that the judge signs appointing the personal representative of the estate. And I know it sounds weird when I say letters is a document, and that's because letters is a one-page document called letters. It's not a letter from the judge. It doesn't say, "Dear John, you have been appointed as the personal representative of the estate. Love, the judge." Right? It's a form called letters. And that document that's called letters is what allows a person to get access to the assets in the name of the deceased person. That person takes letters down to the bank or gives it to the realtor or to the financial advisor to get access to the assets. And then we open up a new account in the name of the estate and we get a tax ID number for that account. The personal representative then starts to consolidate the assets. They take the money from this bank account and put it into the estate account. They take the proceeds from the sale of the car, put it into the account. The proceeds from the sale of the house. And then the money has to sit there for a little bit. Because the next thing that we have to do is we have to publish a notice to creditors in the county paper. And that gives all creditors 4 months to come forward and present their claims. Creditors always get paid first, and the beneficiaries get whatever's left. So that means that money is going to sit in the estate for a little while until we know who the creditors are. During that period of time, we're working on the accounting and the inventory of the estate to show what the assets are and exactly how all of the money in the estate has been spent. At the end of 6 months, when everything has been taken care of, meaning everything has been sold that needs to be sold, all the bills that need to be paid are paid, and all the taxes that need to be paid are paid, because even if you're dead, the IRS still wants their money, right? Once all the bills and the taxes are paid, then we can distribute the estate and close. Most states take, I would say, between 6 months to a year, but by law, it takes at least 6 months to go through the probate process in Colorado. So that's probate in a nutshell. Thanks for listening.